I want to begin by making one point that I was asked to do so, that I mentioned in the last session as well. Any opinions these people have are just their personal opinions and not necessarily represent any position that their firm or otherwise might have here. The next thing I want to do is just have each person introduce themselves briefly. As you well know, their biographies are in the back of this book, so you can get more information. But please just go down and say who you are and what you're going to talk about, and then we can begin.
Okay, excellent. Good morning, Your Honors. I'm Adrienne Busby from Faegre, Drinker, Biddle, and Reath. I'm resident in the Indianapolis office. I'm a partner in the Product Liability and Mass Torts team, where I'm the co-leader of our Science and Experts subgroup. I, spirit of full disclosure, haven't litigated any of the cases that we're talking about here today myself, but I do tend to work on the science-specific teams in mass torts in primarily medical device, but also pharmaceutical cases.
Morning, everyone. Brandon Bogle from Levin, Papantonio, Rafferty, right down the road in Pensacola. Excited to be here today. My practice focuses largely on complex pharmaceutical cases. Again, I was not involved in the Accutane case that I'll be talking about, but my firm certainly was, and looking forward to talking about that with you guys today.
Good morning, everyone. My name is Cynthia Garber from Onder Law. I am a plaintiff attorney handling medical, pharmaceutical, and medical device cases, and also a registered nurse. I tend to be involved in the leadership by way of science experts of a case and working up the case from that standpoint. Thank you.
Good morning, everybody. My name is Craig Woods. I'm with the law firm Mayer Brown in Chicago. I've been doing mass tort and product liability cases for the better part of 25 years. I'm a partner in our practice there. I guess along the same lines as other disclosures, I haven't been involved in these particular cases, but I've handled certainly a lot of expert issues and various toxic defense trials, including asbestos, and one of the substances that was talked about in the panel before me, PFAS, is one of the areas that I've been involved heavily in.
And I'm still Jim Stengel. I wanted to claim I was the better-looking twin, but that would strain credulity, so let's do that.
So we're going to begin with a interaction, a little bit different format, on Accutane, and from what I've been told, to some extent a discussion about the lessons learned or to be learned from the Accutane litigation over the last, quite a few years now.
Yes.
So please begin.
Great, thank you, Professor. So when we think about the Accutane cases, what we're really going to be focusing our comments from the defense and the plaintiff's perspective on today are the New Jersey rulings that came out in 2018 and in 2020. You've been hearing a lot about epidemiological studies, cohort studies, case control studies. How do you balance human data versus animal data and case reports? So all of those things come into play with the Accutane litigation. So as we do that, we thought it would be helpful to have a quick introduction to some of the disease states and what we're talking about so that you can understand how the cases broke down. So Accutane, or isotretinoin, is a vitamin A derivative from the family called retinoids, and it is a very widely used and extremely effective medication for the treatment of severe nodular acne. The typical course for a patient on Accutane is about 15 to 20 weeks, although for very severe cases, a subsequent course can be taken. At issue in these cases is the allegation that Accutane was causally related to the development of inflammatory bowel disease. There are two types of inflammatory bowel disease that we'll talk about. One is ulcerative colitis, and the other is Crohn's disease. Now, these are two different diseases. They do share a number of similarities. Crohn's disease is distinct in that it can occur anywhere in the digestive tract. They have similar symptoms. They have similar risk, although not identical risk factors, but similar risk factors such as family history, history of infection, potentially environmental triggers. But one of the things that's very important as we work through this is, as of today, scientists do not know exactly what causes either ulcerative colitis or Crohn's disease. So moving back to Accutane, it was approved by the FDA in 1982. About 1 in 5 preclinical studies subjects experienced some form of gastrointestinal upset. And so in 1984, the label was amended to include the phrase that it may be temporally associated with inflammatory bowel disease. And we're going to talk a lot about terminology and the importance of terminology, so temporal association is very important in that context. Between 1982 and 2000, approximately 20 million prescriptions for Accutane were written. And the reason why those numbers and that timing is important is because the first case report collection that was published in 2006 looked at the FDA case reports as of that time, and there were 85. This is also significant because, as Brandon will talk about, the litigation was in full swing by then. An MDL had been created in the Middle District of Florida in 2004. The consolidated New Jersey cases that we're going to focus on began in 2005, and the first epidemiological study about the association between inflammatory bowel disease and Accutane wasn't published until 2009. So that's a bit of background and just some of the concepts, and Brandon's going to help understand the background of the litigation.
Yeah, and as Adrienne mentioned, the litigation largely occurred in state court in New Jersey, in Atlantic City. There was also an MDL, but that's not predominantly where the most significant events occurred in relation to what we're talking about here today. And it's significant also in that there were actually 9 trials that occurred, 9 jury trials that occurred with Accutane, several involving multiple plaintiffs. So a total of 14 plaintiffs had their cases tried to a verdict before we ever get to the point of the decisions in 2018 and 2020 that we're going to delve into here. And many of those actually resulted in plaintiffs' verdicts from the juries. And in addition, the cases started out in Atlantic City with Judge Higbee. She oversaw the cases for a significant period of time and actually was the judge overseeing all of those trials. She was then promoted to the appellate bench, and Judge Johnson took over thereafter, and he's the one that wrote the opinions at the trial level that ultimately made their way up to the appellate court that we're going to talk about here today. The other point that I wanted to make now is, since we're talking about the litigation in New Jersey State Court, New Jersey has not adopted Daubert per se. They have a standard called Rubinic or Rubanic. It's very similar in that it focuses on the methodology of the expert rather than sort of the Frye-based general acceptance tailored standard. But in the 2018 opinion that we're going to talk about related to Crohn's, they do adopt the Daubert factors while not expressly adopting Daubert. And one thing that's interesting that I think Adrienne wanted to comment on is sort of the focus in those opinions and the pride that New Jersey had in sort of being ahead of the federal courts with Daubert. So maybe commenting on that might be useful here too.
Yeah, sure. You can see in looking at the way the courts in New Jersey handled this, and in particular, once it got to the Supreme Court of New Jersey, a lot of treatment to the development of New Jersey law is given. And there's a great deal of pride there because they were looking at the soundness of methodology, the reliability criteria, even before Daubert was decided. So ultimately what the court said, the Supreme Court I should say, in 2018 was there's not a lot of space between the way we evaluate reliability and the way that the Daubert criteria evaluates it. So you can consider those criteria, you're still following New Jersey law, but you can consider those criteria. So that's how the two pieces, Daubert and New Jersey law, came together in that ultimate decision.
Yeah. And one thing that we wanted to talk with you guys about here today, rather than going sort of study by study, there were 9 specific epidemiologic studies that were discussed in the opinions. In addition, there were animal studies, case reports, post-marketing adverse event reports with a discussion of challenge, de-challenge, and re-challenge with many of those reports. But one thing that we wanted to talk about today were sort of, some of the things that stuck out to us from the opinions themselves, and then we'll kind of transition into what we think are some key takeaways from those opinions. And so maybe I'll jumpstart that discussion. And one thing that struck me with both of the opinions in the appellate level were the focus on the hierarchy of scientific evidence and the discussion about what weight you put on various levels of scientific evidence. And one thing that, from a plaintiff's perspective, when I read those, that struck me was, while I think it's sort of not fairly debatable that case control studies, randomized placebo-controlled trials, those are at the highest level. Animal studies, case reports are certainly at a lower level than that. But one thing that again struck me from a plaintiff's perspective is that in the analysis by the court, we didn't feel that there was necessarily due consideration put to some of the weaknesses of the epidemiologic studies, which quite frankly, in our view, put them more akin to the level of the animal studies and in that realm. You know, one example was the Bernstein study, which showed no increased risk for IBD, but they used a database out of Manitoba in Canada, which actually, that geographic area had an elevated risk for IBD in that general population. So if you look at that study from that perspective, one concern that raises is whether you can truly detect increased risk with Accutane by comparison if the background rate in the group being considered is already elevated. So that's one thing that I think was key to me in looking at these decisions, is not only the discussion of the hierarchy of evidence, but the consideration that needs to be put into the specific studies themselves and where they might fit into that hierarchy, above or below where they might fall in the pyramid generally.
Right. And so from my perspective, when we look at this came before the court in 2014 on a Kemp hearing, which is the scientific hearing in New Jersey. And at that time, you had these 9 epidemiological studies. When you look at the studies themselves, they build. So Bernstein comes first in 2009, and Bernstein describes data from the provincial health insurance entity, so payer data, and they draw out the data from that. They make the conclusion that there is no association. And then the next studies come along, and they come in pretty rapid succession. If you think about 9 epidemiological studies in 5 years, they each build. So you see the next study, which is the Crockett study, and that's the one study that says, well, there might be an association between the use of Accutane and ulcerative colitis, but there isn't with Crohn's. And then following on the Crockett study, you have Entmanen, which takes the same set of data, but then does a nested cohort study, which means they take a piece of that population and evaluate it to look at that and say, can we replicate that conclusion? And Entmanen's conclusion was, no, we can't replicate it. And replication is a key pillar of the scientific method. Then you have Al-Hussein, and you have all of these subsequent studies that are looking at different populations, and they are not just existing independently in time. They're commenting on the cases that preceded them, and they're saying things like, I'm looking at Crockett and that couldn't be replicated. What if I can account for that confounder, and here's how I'm going to do it? So these cases, these studies, I should say, are different than what we see in some of the mass torts, where you have this entity here researching this issue, this entity researching, and they're happening in pockets. These were happening in succession and building on one another. So ultimately, what the court determined was, this is a consistent set of 9 epidemiological studies that the conclusion from them is there is no association between the use of Accutane and either form of inflammatory bowel disease. And the one study, Crockett, that flipped that couldn't be replicated. So it wasn't an individual study, it was the body of evidence. It was the universe of epidemiological studies that had such a profound impact on this litigation.
Yeah, and I actually want to pick up on one of the last concepts you talked about there in replication. Again, 9 studies that we're talking about. The Crockett study shows a statistically significant increased risk. There are then a body of other studies that showed no risk, and then there were 2 studies that showed increased risk, but not in a statistically significant fashion. And so I think the last panel talked about this a little bit, and I think there are certainly different views on the different sides of the V here on statistical significance with studies. But from the plaintiff's perspective, in our view, while you certainly should take that into account, in our view, that is a form of replication of the Crockett results. Again, albeit not in a statistically significant fashion. But again, I think that's something that we debate a lot in these cases and have to delve into statistical significance in a lot of the cases that we deal with. And that certainly was prevalent with the Accutane case here with a couple of those studies.
Sure, and I do think that was among the debates that the court had, but from my perspective, what it comes back to is the reason why the Supreme Court decided that this case was the right case to talk about how to evaluate the methodology of a well-credentialed expert. And I should have said this at the outset. There was no debate that these all, on both sides, that these experts were well-credentialed. There was absolutely no debate. They have impeccable education credentials. They're from respectable institutions. All of those things were in place. And by the time this came to the Kemp hearing, you can imagine we'd had a decade of litigation under our belts. The people were invested, both emotionally and financially, in the outcome here. So this was a case that the court looked at and said, this is an adversarial case. You have a complete record. This is the right time to do this. And when we're thinking about statistical significance and that debate, ultimately, what the New Jersey Supreme Court said is, it doesn't matter how the lawyers debate it. It doesn't matter how the advocates do it. How do the scientists do it? Because if the scientists that come into court aren't applying, and this goes back to the Kumo standard, if they're not applying the same level of intellectual rigor when they come into the courtroom that they would if they were in their typical day job, then that's not reliable science for the courtroom. And ultimately, that was the problem. If statistical significance matters to a non-litigation epidemiologist, it should matter to an epidemiologist who's testifying in litigation.
And I think the point you make, which I agree on, is that there was certainly a robust record for the court to work from here. And I think that one thing that robust record allows us to make extrapolations based on is there certainly were some significant takeaways, I think, from both sides. When you look at the analysis the court undertook, the nature of the studies themselves, the way the experts presented their opinions. And so I think it'd be useful for us to talk about that as well. And one key takeaway that I had from a plaintiff's perspective, as Adrienne mentioned, the litigation had already been going before the epidemiologic studies really started coming out and being published. And it goes back, honestly, to the age-old question that plaintiffs' lawyers have to face, which is, when do you jump in and file that first suit? Because you have the on one side is the science where I need it to be, and oftentimes on the other side you have issues like statutes of limitations where you at some point have to jump in, or you're standing on the sidelines to your client's detriment. And I think this is a great example of that sort of tug of war that you deal with as a plaintiff's attorney as to when you jump in. And I'm certainly not saying that they jumped in too early here, but it's certainly a factor that we deal with, and I think is highlighted by this case.
Yes, and that's the way the system is structured. You have to deal with statute of limitations. You have to deal with discovery periods. You have to deal with all of that. Ultimately, though, my takeaway is that this gatekeeping function for the judges is a difficult. You guys have been doing this for several days. You're here because it's difficult, but this is a difficult, but it's a critical function because our system is designed so that these cases are going to come before the courts before there are well-accepted epidemiological studies. The issue is not whether there's general acceptance of an opinion. The issue is, are we applying the proper scientific method? Because that doesn't change. That's consistent. So when these cases come up, in my view, the fact that it's novel, that's what makes this gatekeeping function so much more critical, because the judge's determination of reliability is, and this is how the New Jersey court framed it, it's a legal determination. It's not the same as credibility that is the province of the jury. It's not the same as qualification. It's scientific reliability as a legal determination of admissibility. And it has to be given due time. It has to be built into the case management orders so that there's time for the parties to do this. We were talking to Judge Novi here a moment ago, and he was talking about how in Texas there are special courts that are dedicated to doing this. And I'm sure that in those case management plans, they're building in the time to do this. We talked about science days. In certain cases, like these mass torts, there has to be time for this to develop. In my view, one of my key takeaways is for these litigants, no matter how long they've been in the process, the right answer is not, you're so invested in this, you ought to be able to have your day in court in front of a jury. The reality is, your day in court might be a Daubert hearing. Your day in court might be a science day where you figure out if general causation can even be supported. And that makes the role of the judge in determining reliability that much more important.
Yeah, and I think to that point, in many cases, your final day is your Daubert hearing, and when that's the case, I mean, it sort of underscores where we started here, which is when you file and when you start to pursue the litigation is key, and is the science where you need it to be or want it to be to get past that Daubert hearing in a way that you hope to. So I think they all sort of the two concepts interrelate in that respect, for sure.
I also think a key takeaway that we've talked about quite a bit is the proper use of the terminology. You know, distinctions matter here. Causation and association are different things. Reliability, credibility, qualifications, those are different things. And in, you know, let's be honest, in the haze of advocacy, we may conflate those terms, but I think it's to the judge to hold the parties to specificity and to keep coming back to the concept of scientific reliability, and is this based on a method that a scientist would use outside the courtroom?
Right. I think we've run through our time here, so we'll cede the remainder to the Roundup team there.
Are there some questions from the audience? I don't have anything online here. I just wondered.
We must have answered everything.
Well, no.
All the world's problems.
Don't worry. The moderator has a question. So
That works.
I'm intrigued, especially because of this Accutane opinion about animal studies, and I don't mean to say that what I'm about to say is the fact, but I just like to take it as a background assumption. The assumption that I'm going to make is that the epidemiology doesn't show a relationship, or we could say there is no epidemiology. And then the question is, what role should animal studies play, if any, in trying to resolve the general causation question? Do you have a view on whether animal studies alone could ever do the job? It's clear, just to finish my point, it's clear that in this case, as in many, many cases, the court says, in the face of a substantial body of epidemiology saying no relationship, animal studies never seem to be enough. That's my takeaway from part of the Accutane opinion. But there's a lot of other cases where there isn't much epidemiology. And I'd like your thoughts about what to do with animal studies when that's all we have.
Take it first?
Yeah, so I think from a plaintiff's perspective that, and this was true in Accutane, we felt the animal studies were significant and supported causation. While saying that, though, I am personally of the belief that it would be a rare circumstance where you could say that animal studies alone would support a finding of general causation. Even as a plaintiff's lawyer, I think I would have that point of view. But I do think they're an important cog, an important thing to consider when you're doing the overall assessment on general causation. So I think that they certainly played a key role and component in the Accutane case itself as well.
Yeah, I certainly think sometimes that's what you have, and you deal with what you have, because for a variety of reasons, maybe ethical reasons or otherwise, those are the studies that you have that are available to you. In the Accutane litigation, this was hotly debated in part because some of the animal studies were conducted by Hoffman-LaRoche to look at intestinal irritation. But in terms of extrapolating from the studies that you have a causal relationship, they are using dog studies. Dogs can't get inflammatory bowel disease. So it's not just that the animal studies exist, it's how you use them. Can you use them to show the temporal association? And again, this comes down to distinctions: acute versus chronic, temporal versus cause. These things are important. So should they be considered? Sure. But I think they have to be considered in the proper light and with the relevance. So, I don't think there's a generalized answer, but at least with respect to IBD, this is not an animal that can have the disease state. So you have to put that into context.
And I think that goes back to the hierarchy of evidence concept we talked about before. I mean, it's like any other study. There may be animal studies that are more pertinent to what you're analyzing, and sometimes they're less pertinent. In this circumstance, I think the court certainly relied heavily on the fact, as you pointed out, that the dogs can't get IBD. So in their view, that was a less relevant animal study in this context. I think you certainly have other contexts where animal studies can play a more prominent role, but then it comes down to just looking at the design and the conduct of the study itself, just like with any other epidemiologic study.
And that's something the trial court here did really well, by the way. I mean, the trial court got into these studies, and that takes time and effort. But if you could look at the opinions, you can see how deeply Judge Johnson looked at this.
While we were talking, a question came over the wire, so to speak. So let me just read it, and then after this, we'll turn to the other topic.
Sure.
The question is this, from the plaintiff's perspective, so we have a point of view here.
All right.
Is statistical significance outdated? I don't know that I would have used the word outdated here. Paid too much attention to might be another way to put the question.
Yeah.
And is it more important, the question goes on, to focus only on the risk estimate, the relative risk estimate? So
Yeah,
the question is the role of statistical significance.
Yeah, I wouldn't call it outdated. I think that certainly it's something that should be considered and certainly is considered. But I think from my perspective, you have to again look at the study in its totality. And that's one element of the study, is whether it was statistically significant in its findings. But from my perspective, I don't think that's the end-all, do-all for that study if its findings are not statistically significant. So again, I just think you sort of throw it into the soup as another factor, but I don't view it as something that's dispositive of whether you consider the study or not.
I think we're ready to turn to Roundup. So feel free. I'm not quite sure how you're going to distribute your time, but 7 or 8 minutes apiece, I think, somebody 6. Anyway, go for it.
I think, Craig, Jim and I are going to talk to you about Roundup, and I guess I'll begin by just giving you an overview. Roundup, as you probably know, is a broad spectrum herbicide, and the active ingredient is glyphosate. That's the chemical at issue. And the disease at issue is NHL, or non-Hodgkin's lymphoma, which is a blood cancer. And the issue before the court, which, by the way, there's consolidated matters in California in the Northern District before Judge Chambria, and also in California State Court in Alameda County before Judge Smith. And in both of those consolidated matters, the issue before the court was, does Roundup and its active ingredient glyphosate cause NHL? The experts in the case, and we're going to focus specifically on the Daubert decision in Judge Chambria's court. But the experts relied on the scientific body of evidence, or the totality of the evidence, which came from the various areas, including agency statements, the position of the EPA, and the position of IARC, which is a branch of the World Health Organization, epidemiological data, that was comprised of case control studies, backward-looking studies, cohort studies, forward-looking data, meta-analyses, and then additionally animal studies and mechanistic studies, studies like in vitro studies and the like. And that body of evidence was debated amongst the experts, plaintiffs' experts focusing on the case control studies and the reasons why that body of evidence was more compelling to their opinions. And the defendants, I think it's fair to say, were more focused on the cohort studies. And then the conclusion of the court, we will discuss how the court came to its opinions. I'm going to pass along to Craig to kind of give you maybe some of the overviews of the science.
Sure. So one of the things about this decision is it's a good lesson, I think, in the task that the court has to undertake to do a Daubert hearing. Both in the Accutane decision and in the Roundup decision, the court was not focused on the conclusions of the experts, what they were saying, causation or not. The court was really focused in both cases on what was the method that they got there. How did they conclude that in Roundup case that Roundup caused NHL? What was the basis for their causation decision? And it's shown, I think, by the fact that in the Roundup decision, the court excluded some experts and allowed some experts in who were saying exactly the same thing. And I'll talk a little bit about what the distinctions between those two that the court drew. But essentially, the plaintiffs in the case were relying heavily on a decision by IARC to deem glyphosate a probable carcinogen in humans, and on a series of case control studies, a lot of which showed some statistically significant increased risks of NHL. However, when those analyses were controlled for other pesticides, so you can imagine a lot of the people in these studies were farmers who had applied these chemicals. They also had applied a lot of pesticides and a lot of other chemicals. So one of the things that the studies had tried to do, some of them at least, was can we control for other exposures that might also explain the NHL? So a lot of the studies were positive. They weren't hugely positive in terms of relative risks or odds ratios. They were all around 2 or less than 2. But when they controlled for other pesticides, none of the studies were positive. Or none of the studies were statistically significant, sorry. And so one of the things that some researchers had done to try to tease that out was to do what's called meta-analyses. I don't know if you're familiar with that, or pooling of data together. And what the benefit of doing, one benefit of doing a meta-analysis or pooling the data together is you have more subjects. So you can, it's easier to exclude chance if there is a real effect. Because small sample sizes are going to have very large confidence intervals. If you have a large sample size, you can have a much narrower confidence interval, and then if there's an effect, maybe you can see it. The meta-analyses that controlled for, or that only included the studies that actually controlled for other pesticides came up, I would say, borderline positive. They were in the range of 1.3 to 1.4. The confidence intervals were right at 1. So you could argue it's not really statistically significant since you have to exclude the null, but they were borderline positive. That's what the plaintiffs were relying on. The defense was relying, as Cynthia indicated, on a prospective cohort study, which in general, I think most scientists would agree could be a better form of study than these case control studies. You can deal with some biases in the studies a little better. However, as the plaintiffs argued, that prospective cohort study had issues with actually determining who was exposed and how much. And if you have problems with ascertaining exposure, you can have what's called differential exposure misclassification that basically hides any effect. So the plaintiffs argued, yes, it was a good study design in general, but they weren't able to tell what the individual's exposure was precisely enough so that any effect would be masked. So the court was focused on, was plaintiffs' discounting of the cohort studies justified? Ultimately, the court concluded yes. There was reasons to think that maybe those null findings in the cohort studies, which were all negative and fairly solidly negative, they were the largest studies out there. The court was agreed that plaintiffs could discount those. That was scientifically reasonable not to count that as a negative because of the possibility of exposure misclassification. And with respect to the cohort studies, the judge found that yes, it's true, it's only modestly positive, but I'm going to let the plaintiffs say, well, there's a number of studies that have shown a positive that's not statistically significant. If you combine that with some other evidence in the case, they were pointing to animal studies as well as some mechanistic studies, that was good enough. So while in the Accutane case, I think the court came out, there's no statistically significant effect here, the judge in the Roundup cases seemed to be saying, well, I agree, if you look at that meta-analysis where they actually controlled for other exposures, it's borderline positive, but it's a really low risk, but I'm going to let the plaintiff say there's causation here based on that, the fact that there's a number of studies that were positive, although not statistically significant, as well as the other evidence. That's the real challenge. I think we've talked about it in the panel before and in this panel. What's the role of statistical significance? I think the judge got exactly right that his role in the case was to examine the underlying methodologies. And the plaintiff's experts had relied on Bradford Hill, and the judge got right that in order to rely on Bradford Hill, you have to show first that there is actually an association at issue. And in order to show an association, you have to account for bias, and you have to account for chance, which is statistical significance, and you also have to account for confounding. And so I think the judge was asking the right questions. The issue is, was that sufficient or not? I mean, from the defense perspective, I would say no. I'm sure Cynthia might have a different view on what the evidence showed. But that's really, I think, the challenge in these cases sometimes is getting into the weeds and understanding what is the difference. How can this expert say this is causation? And do scientists in the field do those sorts of things? Is that how they distinguish these studies? Is that how they treat these studies? In the Accutane case, it was pretty apparent from the plaintiff's experts that they were using one methodology to exclude these epidemiology studies, but relying on some of the same methodology to account for other studies. So they were inconsistently applying their kind of exclusion criteria. In the Roundup case, that was debatable whether that was the case. Monsanto obviously argued that was the case. The judge felt, though, that the experts had reasonably interpreted the evidence, and the justifications they gave for crediting the case control studies and discounting the cohort studies were sufficiently grounded in the scientific principles that the experts could testify.
I just want to focus on a narrower issue out of the Roundup litigation, which is really fascinating in terms of how courts deal with conflicting regulatory pronouncements or positions. This is a unique situation, in part driven by California's Prop 65 regulations, where you had the EPA, which regulates herbicides and had done several rounds of evaluation of glyphosate, coming to the position that they did not cause cancer. Litigation was brought under Prop 65 to force a label to be affixed on glyphosate products in California to say this is a cancer-causing agent. EPA's position was that would be misbranding. That would be a criminal violation of FIFRA to label that way. Now, the case went forward on a failure to warn basis, among other grounds. And I think Judge DeHabery, who's a very good judge, very smart, very well regarded, got some things very right and some things, in my view, wrong. The things he got right is his treatment of IARC and how the experts used it was, I think, spot on. He was basically saying, look, it's there, you can use it, but don't come to me having done no independent work and just parrot what IARC said. You know, we don't need that. That doesn't add value from an evidentiary perspective. And he excluded some experts and permitted some based on how they had utilized IARC and whether they'd done independent work. Where I think he got off base on IARC was trying to deal with this clash between the EPA and IARC at trial, and this is pending on appeal in the Ninth Circuit right now. He allowed the plaintiff, and I wasn't at trial, so I don't know what the background was, but he allowed the plaintiff to put in evidence about the IARC finding. And Monsanto came back and said, well, if that comes in, then EPA is fair game. He'd exclude it on an eliminate basis. And he basically said no. And one of the grounds that Monsanto Bayer have on appeal is that created an asymmetry in terms of the jury being told about IARC's pronouncement, but not knowing that in a failure to warn case, it would have been illegal to affix the label the plaintiffs were asking for. So I don't know whether the Ninth Circuit's deliberations are going to be in all impacted by the settlement dance that's going on right now. I suspect not, since there's so many people who hate the settlement. It would be probably a fool's errand to bet that it was going to go through. But I think from your perspective, as judges have to deal with these issues, I don't know of another case where there's been a clear clash between one regulatory body, actually the only regulatory body. The IARC view is purely advisory, obviously. But you do have very dramatically different assessments by non-parties.
Yeah, one of the interesting things about the IARC determination is, in terms of the Daubert hearing, the judge determined that IARC's determination was not a causation determination in the sense of what a jury has to hear, but instead it was what's called a hazard analysis. And so the experts who had just relied on IARC's hazard pronouncement weren't providing, their opinions actually didn't fit the question the jury had to decide, which is causation in an individual tort case.
Yeah, on that score, if you have a case before you that involves an IARC evaluation, I encourage you to read the IARC preamble, because they lay out very clearly what they think their observations are good for, and they're very limited. They make it quite clear, look, we do hazard identification. We think this could be a problem, but we're going to leave it to domestic regulatory institutions, like ironically the EPA, to make the risk assessment, that is the concrete evaluation of whether there's a causal or associational link. But IARC has triggered a lot of mass tort litigation, and a lot of judges and parties don't bother to look at the preamble and see how limited the IARC findings are supposed to be.
I was just going to talk a moment about lessons learned, going forward. I've been involved in the talc litigation and in the Roundup litigation and expert reports. And there's a similarity, I think, between the opinions of Judge Wolfson and Judge Tambria. And I think it's interesting that the court seems to be saying, two professionals can disagree, and as long as the methodology was there and it was sound, and you relied on different kinds of evidence and said that was more important to my opinion and bolstering it, still does not render one of those experts inadmissible, so long as you considered it all. And it wasn't cherry-picked, and we always hear that, in the opinions and in the hearings. And so to avoid that cherry picking, what I learned and what I heard is that the expert really considers the totality of the literature, the different, let's just say, the epidemiology. And are you considering both the strengths and the weaknesses of that literature, and are you addressing that? Are you just omitting, I'm not even going to look at the cohort studies because I don't like them, they go the wrong way for my opinion. No, you can't do that. You have to address the cohort and say, okay, yes, there are these strengths, but there's limitations with that data as well, and here's what it is. But after I look at the totality of the literature and look at it in the context of Bradford Hill, I'm coming up with a well-reasoned opinion about causation. And as to the credibility of that opinion, we leave that for the jury to decide. But those two opinions, even though they're different and they're bolstered by different kinds of evidence and different arguments about the evidence, are still admissible. So that's sort of my takeaway.
Yeah, I would agree with that. I think that is the focus of what the Daubert inquiry should be, is what is the basis for what the expert's doing here, and did he apply a scientifically justified and supported methodology to reach that conclusion? Is it just his reasoned judgment, or is it based on a reliable methodology? Is it subjective, subjective in nature or not? So I think that's critical.
Are we ready for some questions, y'all?
Sure.
Sure.
First of all, I'd just like to say, to follow up on that last point, that I really agree that we should pay more attention to, at least in the federal courts, to the new 702 and use that as the basis for admissibility decisions rather than the Daubert language. My personal bias is the really important factor is whether the data is sufficient to support what the expert wants to say, and we should really focus on that kind of local sufficiency is the key thing to look at. Is there enough support for this? And in fact, in some of these cases, experts relying on animal data were allowed to testify about certain things that animal data show, that is disruption of inflammation, but they weren't allowed to make the larger leap, which is that the animal data shows that there's causation in humans. So I think it's always important to figure out what the data says and exactly what the expert wants to conclude from that data and decide, is that a reasonable conclusion given the data we have? So I think that's what you said, and I just want to emphasize, I think that's the easiest way to try to approach this problem. If I were a judge, that's the way I'd want to think about it. I have a bunch of questions here, but so I'll save my own and address the ones here. And if we have time, I'll come back. The first one is appellate review of expert exclusion. What could constitute an abuse of discretion? And I presume what they mean here is the trial judge has abused his or her discretion in terms of excluding or including. And then there's a follow-up question to this one, which is, what about a denial of a request for a science panel or similar devices as a way to kind of explore the issue? So any thoughts about the abuse of discretion standard or science panels?
I'll start with the science panel. I think the odds of an appellate court saying it was an abuse of discretion not to have one or not to have a science day converges on zero. That's firmly within your discretion. It's something that would be done to aid the judge in his or her task. On the abuse of discretion standard, I think one of the reasons you don't see that many evidentiary rulings on experts disturbed on appeal is because you have a pretty broad range. And I think you have to have something fairly tangible, like ignoring a body of proof. I think, when, let me flip this around on a historical basis, the pendulum has sort of swung back to, the totality of the evidence as an assessment, the Millward standard, and you're less likely to have a judge exclude the plaintiff's case because, they didn't get to 2.0 on relative risk. I think you need something fairly stark like that that's going to really grab an appellate court, and they're going to say, that's not consistent with Rule 702 or the state standard. I think there are probably more procedural deficiencies on the expert evidentiary ruling side if there was a sense that the trial judge didn't fully consider what the opinions were, didn't allow proof. That, I think, can lead to reversals on appeal. But I think as a general proposition, there's a reason this is put in the discretion of the trial court, because you're dealing with the reality of the proof as it's coming in, and I think most appellate courts will respect that.
Yeah, I agree with that. I think it's interesting if you look at the way the Accutane litigation shook out. The trial court judge conducted a Kemp hearing, got very involved in reviewing all of the studies, issued a detailed opinion. The appellate court then said, we're looking at this and we think that a trial court's decision on expert testimony exclusion is entitled to something a little less than abuse of discretion. And I wonder, although they didn't say this, but I wonder if that's because the way New Jersey had formulated their standards, they had talked about it being a slightly relaxed standard. And I think that the appellate court...
The appellate court was moving the goalposts on the trial judge. They were saying, we want to go a different direction with evidentiary standards.
Right.
And you're not up with us yet.
I think that's right. And then what they ultimately said was, listen, you've got some very well-credentialed experts here who have a difference of professional opinion. The Supreme Court said, no. First of all, it's abuse of discretion because the judges have the well-developed record in front of them. Absolutely, it's abuse of discretion. And then they went on to say, look at what the judge did in digging in. And they actually called his opinion unassailable. So, I think that's one of the ways that you want to look at it. And this dovetails with the point you made, Professor, that the idea of the amount of data is really important, but what we're seeing, it's what you do with the data. It's do you have sufficient data, but are you reliably applying the scientific method to that data? You can have a lot of data and cobble it together, and you're not going to end up with a reliable expert opinion. And that was ultimately what the judge said the problem in Accutane was. They didn't reliably apply the method to all of this body of data because, as Craig said, they liked a conclusion here, they liked a study there. part of the conclusion they were willing to accept. This part they weren't willing to accept, and that wasn't enough. They found it to be results driven. So you're right. I think cherry picking is one word. The other phrase is results driven. It was a results driven opinion.
Yeah, consistency of analysis, I think, is absolutely key. And I also agree to the point that when you're talking about abuse of discretion and what that might constitute, I really think you would see it most frequently in the context of excluding specific areas of proof that the expert considered. He considered animal studies, but I'm not considering that at all. I think that's where you get into that range. Otherwise, I think it's obviously a very deferential standard to the trial court.
So I have another question here, which is a good one. I wish I'd asked this question. I can't take any credit for it. I don't think we talked about it very much, but in the Roundup opinion, in several places, the judge talked about the uniqueness of the Ninth Circuit. And so the question is exactly that question. It says, federal Roundup decisions suggest that the opinions pass muster in the Ninth Circuit, but maybe not elsewhere. Can you comment on that?
Well,
I didn't write this question.
That may not be that wrong. I mean, there is, I think, a difference in the ways some circuits interpret Daubert and how strictly they apply the requirements. It does depend by where you're at, no question.
I think the Ninth Circuit has staked out a more liberal position. I don't know that it's as liberal as Judge Faegre thought it was. So it'll be interesting to see what the circuit does with that. It's also going to be interesting. I mean, the Ninth Circuit's huge, lots of different judges, lots of different viewpoints, and who gets to decide this and whether it's reheard en banc will be fascinating, because I do think it goes to a fundamental issue of expert evidentiary treatment.
Do you, ladies and gentlemen, have any sense? Can you describe what the difference is, other than using the words liberal and conservative, or more lenient or less? Is there? I mean, my sense is I agree that that's right, but I've never had a very easy time doing anything more than expressing this sort of global idea about being more lenient. Do you have any sense of maybe not?
It's defining pornography by I know when I see it. I think the problem is, this gets back to the discretion point. He could have excluded most of the plaintiff's evidentiary case on epidemiology, I think, and not been at huge risk of being overturned, because he said this himself. He kept repeating this, the plaintiff's evidence here is really thin. I don't know where I'm going to go. So I think he could have gone either way. I think it was more of an attitudinal assessment that in the Ninth Circuit, disqualifying experts under Daubert 702 is disfavored in some way. That the tendency is we want more things to go to the jury or the finder of fact. And again, that's not really an answer to your question, because I can't give you the bright line. But I think from a kind of Gestalt perspective, that's really where it comes down. If you're going to lean one way or the other, you're going to lean in favor of admissibility.
In fact, I'll smuggle my other question in here before I get to this last one. It leads to the other question. In one place in the Roundup opinion, the judge repeated something that's been argued, that was all the way back in Daubert. And I'll just read it. Vigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof are the traditional and appropriate means of attacking shaky but admissible evidence. That's a quote from the Roundup opinion. And if I could just for a moment put on my social science hat rather than my law hat, we have a substantial body of social science now that says that cross-examination almost never successfully counteracts bad expert opinion. So I just like your thoughts about what role these traditional adversarial devices play and how successful they really are in helping the jury resolve difficult questions of scientific proof.
Well, I'll jump in.
Yeah.
Because I can't help myself. It goes back to what we were talking about which determination belongs to the court and which belongs to the jury. Reliability is a legal determination on admissibility. And if you don't satisfy the scientific criteria and the reliability, then you really have no business presenting to the jury, because that's what the gatekeeping role is about. It's about the idea that a jury should not hear something from the commanding voice of a well-credentialed expert that doesn't pass muster as reliability. Once you've determined that the method is reliable, that's how you get to the jury. And then the jury can decide whether or not they like you. They can decide whether or not there's credibility there. But my concern about that observation is that it blurs the line between reliability and credibility. And when that happens, we're putting in the hands of the jury something that the jury shouldn't be doing. This is outside the ken of the jury. And frankly, the result is wrong. Whether it's no matter who wins, it's wrong. From the defense perspective, I get worried about this because when you ask a jury of laypersons to decide scientific reliability, we're looking down the barrel of enterprise risk verdicts. I mean, that's the reality. I mean, these are verdicts that for smaller players are enterprise risks, for bigger players are innovation risks. So I think we have to be extremely thoughtful about what's the quantum of information evidence that we need, and how does that get to the jury, and when does it get to the jury? So clearly a defense perspective.
But I think
I would go back.
No,
sorry.
you please.
Just say quick, and then I'll let you go. I know you want to jump in. I would just emphasize what you said earlier, Adrienne, about the task here is really for the judge to determine, is this expert presenting in court the same level of intellectual rigor that we're seeing in his profession? And that's the threshold that you have to meet. And it's only if you get to that threshold that cross-examination is the answer to trying to decide the weight you would give to the evidence.
Right, I agree.
That's right, and I think what the answer to the question is, it's not the judge's role to be the umpire, it's to be the gatekeeper.
Yes.
And the umpire is the jury. And so it's not the court's role to say which expert is right and wrong. Let the jury decide that. And just if the methodology is sound, it goes to the jury.
And I would say also, I mean, it's a dispositive issue. It's not the same as a summary judgment determination, because in a summary judgment determination, you as the judges are going to be instructing the jury on the law at the end. Once that reliability determination, once it's out of the gate, it's out of the gate. There's no further instruction on reliability. So it's a very, very significant role in the lifetime of a litigation.
There's a question that was from the audience that was touched upon briefly by Jim, but I think a little more would be worthwhile. Here's the question. Was the research relied on in the Roundup California case from the WHO listing Roundup as a Tier 2 carcinogen, fatally flawed, and retracted in science? I don't know quite what they mean by having been withdrawn, but it does raise this general issue of what role things like the IARC findings should have, either as a public law issue about setting policy or as a private law issue of trying to prove causation. And I think it would be worthwhile to talk about that issue briefly.
Yeah, to my knowledge, IARC is not withdrawn its characterization.
Yeah.
What they've done, and they've done it prospectively, not in reaction to this debate with the EPA, is they understand that they operate under a limited sphere in terms of what their pronouncements are for. So I don't think at this point IARC would say, oh, we screwed up. I think they'd say we did a hazard identification, full stop, and we were relying on others to do the full-scale risk assessment. So, we think there's an issue. We're not purporting to determine whether there's in fact causation. That's for others to address.
Yeah, I mean, as an example, IARC relies heavily on animal studies for its hazard evaluation. And generally, there are recognized procedures for regulatory bodies such as IARC to interpret animal studies. And one of the things that is typically done is if you don't know the mechanism by which some effect occurs in an animal, then you assume that it applies to humans. Whereas in general, whether it applies to humans is a big question. So in order for IARC to discount an animal study, you would have to demonstrate to them, we know what the chemical did in the animal, and we know that that mechanism isn't applicable to humans. And if you can't meet that standard, they consider that study. So that's a different type of analysis, and it's a protective kind of analysis, I think, then you need to really assess, did someone prove their causation case in court? So it's kind of apples and oranges on that issue. And I think Judge Chabria realized that and appropriately discounted the IARC by itself. He required more than just looking at IARC. He required the experts to demonstrate how they determined causation was based on reliable science.
Here's a good one for which none of us have an answer, but I sure hope the answer is yes, because it'll keep me busy for years. Is there any opportunity the Supreme Court might revisit Daubert anytime soon? Or at least have another opinion. And that's not an entirely trivial question. I mean, I could see this Roundup opinion, depending on what the Ninth Circuit said and whether the case gets settled, as a case that a conservative Supreme Court might like to throw its 2 cents in.
You made a reference earlier that may impact this, because I think as courts in the federal system look at Rule 702 as amended rather than sort of dragging the old Daubert language into every decision, I think it may minimize the risk of a Supreme Court opinion. I don't get the sense that evidentiary standards are high on their lists right now. As I said, those of us on the defense side were bitterly disappointed when they didn't take Millward up, because we just thought that was sort of stretching the outer bounds of what the gatekeeper function should allow. So I think they, although they do have, as they would say, an instinct for the capillary on procedural issues, so maybe they can take that because it won't be controversial in terms of the orientation of the court and the justices.
Here's another one that I think is, I'm going to translate it just a little bit. I'll read the question and then I'll give you my gloss of it. It seems like if all the prongs of 702 are rigorously applied, the argument that it goes, quote, to the weight of weight, not admissibility, should no longer hold. I guess really another way to talk about this is this line between goes to the weight versus goes to admissibility, and any thoughts you might have on that piece of rhetorical legerdemain that is often used in opinions.
I'll speak to the weight issue, because I know in working with experts in talc and Roundup, they do talk about weight. So for instance, let's just say the epidemiology, the odds ratios are just slightly north of 1, 1.2, 1.3. And how much weight did you put to that? And how much weight did you put that it wasn't above a 2? And so did you put great weight on the epi as opposed to the animal data? And I think it's very helpful when the expert explains, I put a lot of weight on the replication of the case-controlled study after study after study in different parts of the world and different study designs and different populations and age. I put great weight to that. And I put very little weight in the cohort study because of all the flaws that I've just enunciated are in that study. And I think that's helpful to understanding how they arrive at their opinion and gives a confidence that it's well reasoned.
Go ahead.
No, and again, I think it goes back to the consistency point. That's where, the judge really has to analyze the things that they're discounting versus the things they're putting great emphasis on. Is there consistency in the methodology to get to those distinctions? And I think that's where you come back to that point too.
I think these are great points that I agree with, but I also think that weight comes into play in 2 ways. Number one, it's what was the weight when the expert evaluated the underlying data? What weight did that expert give it? Which is, as you said, critically important. But when we're talking about the judge's ruling and we say, well, this particular issue goes to weight and not admissibility, in my view, I hear that as that goes to credibility, not reliability. And there's two different ways to think about that. When the judge passes on exclusion because it's really an issue of weight, as long as it's not an issue of the methodology, then that makes sense. But I don't think issues of methodology and the soundness of methodology can ever be issues of weight within the broader context of the litigation. And that's a separate consideration than the weight of how an expert evaluates data.
Right.
Hopefully that distinction makes sense. But I hear 2 different things in that question.
A related question that's not here, but I might ask, is that several of you have talked about is this idea of the weight of the evidence. as an approach to trying to deal with this problem. And of course, it's as old as Joyner, where Pryor really wanted to try that idea. So this idea of looking at the weight of the evidence has been around a long time. We'd like to comment on that. It's obviously a way of saying things that has, by and large, been advocated by plaintiffs, I think. And I'd like to hear any thoughts you might have on this so-called weight of the evidence approach. So-called sounds negative, I didn't mean it. This weight of the evidence approach, that's the jargon that's used, as a way to try to resolve these problems.
Well, I think certainly you see that a lot in these cases, and plaintiff experts primarily point to that. I think it's dangerous to use that term without defining what that means, because it's almost like a black box. Well, I put this, if you look at the weight of the evidence, well, how did you weigh the evidence? And some courts that have grappled with that and allowed kind of the weight of the evidence standard have laid out kind of a criteria for using that method. So you can't just say, well, I think the weight of the evidence goes here. You actually have to justify those conclusions that you made, and you have to lay out a methodology for how you determined that the weight of the evidence was there. For example, you look at the different studies that are there, analyze it under an umbrella of hierarchy of reliability. You know, which of these pieces of evidence provide the most support? Epidemiology versus animal studies versus mechanistic studies. Are you taking into consideration that? And then looking at how you decide of those particular pieces of evidence, how it supports. So it's more than just a black box appellation. You have to have some kind of methodology behind it that you can point to. And there are some scientific bodies that have published criteria, not the strictly a Bradford Hill criteria, but a similar type criteria that you would use to analyze bodies of evidence on causation.
I take a more granular view of that. I think, and this gets back to, you know, we've talked a little bit about the dangers of extrapolating from animal data, which is also true of cellular evaluations. It's hard to make sure that what you're seeing in the lab actually has any application to what's happening in living, breathing humans. But I think the weight of the evidence approach, the part that I don't like, is to the extent it implies we're going to allow a lower level of proof of causation, or association in human-driven studies, and then we're going to jump to animal studies and cellular studies. I think the issue ought to be being clear about what strength of association you need, and this gets back to the federal manual, Bradford Hill, many of the appellate decisions on these issues. You know, how strong do you have to be? Do you have to have sort of an unassailable epidemiological record before you get to these other stages? Or can you, as I think we're now converging, you know, if you're pretty close on epi, we'll let these other things in and see if that helps you bridge the gap. And that also gets to a philosophical question about what judges and juries ought to be addressing.
I think we've exhausted our time, or come close enough to stop anyway. I really want to thank you very much. I've really enjoyed this conversation. Thank you.
Thank you.